Thank you, everyone, for joining us for today's webinar, The Court and LGBTQ Rights, Understanding the Impact of Skrmetti and Mahmoud. We now turn to today's moderator, Christy Mallory, the Roberta A. Conroy Interim Executive Director at the Williams Institute. Christy?
Thank you. And hi, everyone. Thanks for joining us for today's webinar. I'm really excited to be moderating this conversation. For any of you who are new to the Williams Institute and joining us for the first time, the Williams Institute is an interdisciplinary research center focused on LGBTQ law and policy based at the UCLA School of Law. And today's conversation is with Professor Cary Franklin. Cary is the McDonald Wright Chair of Law at UCLA. She's also the faculty director of the Williams Institute and UCLA Law's Center for Reproductive Health Law and Policy. Cary's scholarship focuses on constitutional law, anti-discrimination law, and legal history. Cary, thanks for joining me today to talk about two LGBTQ rights cases decided by the Supreme Court this term. U.S. versus Skrmetti and Mahmoud versus Taylor. Welcome, Cary.
Thanks so much, Christy. I'm happy to be here.
Great. And so just a quick note for the audience. We should have time at the end for a few questions. So if you have a question for Cary, please use the Q&A function on Zoom to enter it there. And we will reserve time at the end for audience questions. So Cary, let's start with an overview of Skrmetti. Can you tell us what this case is about and how it got to the Supreme Court?
Sure. So in 2023, Tennessee passed a ban on gender-affirming healthcare for minors. And the ban covered surgery, and it covered hormones, and it covered puberty blockers. And 3 transgender kids and their parents and a doctor sued, saying that law was unconstitutional. The courts determined early on that the plaintiffs didn't have standing to challenge the surgery ban. They hadn't had surgery, they weren't about to get it. So the case really focused on the ban on hormones and puberty blockers for minors in Tennessee. Let me tell you a bit about this law. So the Tennessee law bars healthcare providers from, quote, prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of, 1, enabling the minor to identify with or live as a purported identity inconsistent with the minor's biological sex, or treating purported discomfort or distress from a discordance between the biological sex and the asserted identity. So the stated purpose of the law is to encourage minors to appreciate the sex they were labeled at birth, quote, and to prevent them from, quote, becoming disdainful of their sex. The law explicitly permits healthcare providers to administer puberty blockers and hormones to treat all other conditions for which they're indicated: congenital defects, precocious puberty, other disease or physical injury. Doctors are allowed to prescribe hormones and puberty blockers for all those conditions, but not if the minor is attempting to identify with or live as a sex that's not their sex labeled at birth. And I just bring this up because the medications at issue in this case, the puberty blockers and hormones, are fairly common. And the vast majority of kids who take these medications are not transgender. They're cisgender. Doctors are treating precocious puberty and various conditions like hirsutism, which is where girls grow hair on their face or other places in their bodies where girls don't generally grow hair. You can give hormones for that. Or boys experience gynecomastia, where they grow breast tissue. You can get hormones for that. So the whole range of conditions in which you can absolutely still prescribe these drugs to minors in Tennessee, but not if the minor's purpose is to move their body away from the norm as opposed to the norm of gender. So the plaintiffs in the case say this is discriminatory. It violates the Equal Protection Clause of the 14th Amendment. And that claim that they make has 3 aspects to it. The first one, this discriminates on the basis of sex. So 2 kids show up, they have facial hair, it's bothering them. The boy is not going to, the person labeled male at birth is not going to be able to get hormones to treat that. The person labeled female at birth can get hormones to treat that. Likewise, you have two kids show up with breast tissue that is making them uncomfortable. The labeled female at birth person will not be able to get treatment. The labeled male at birth person will. So the plaintiffs are saying that discriminates on the basis of sex. Doesn't mean they win their claim, but it says the court should take a closer look. That should be subject to heightened scrutiny because the access to the drug is turning on sex. Their second claim is that this law discriminates on the basis of transgender status. So cisgender kids can get drugs to change their bodies in all sorts of ways. Transgender kids cannot. That should trigger heightened scrutiny or increased constitutional concern. And finally, they argue that this law is based on animus. There's not a valid reason for the law. The plaintiffs are saying the state obviously doesn't think these drugs are dangerous. It's allowing most kids to still get these drugs. What the legislature is really doing is expressing antipathy toward transgender people, denying they exist and treating them cruelly. And they argue that the law should be understood in the context of Tennessee, which is the leading state in the nation in terms of passing anti-transgender laws. They've passed about double as many as other states in the country. Laws, bathrooms bills, sports bans, pronoun bans, laws requiring parents at schools to out their transgender students to parents. And the plaintiffs are arguing this law is of a piece with all of that anti-trans lawmaking. It's not trying to protect transgender kids. It's part of a wave of animus against them. Final thing I'll say is that the plaintiffs also argued that there was a parental rights concern, that they had a constitutional right to direct the upbringing of their children and make medical decisions about their children, and that this law violated that. And the Supreme Court just granted cert on the equal protection question. So that was all that was involved in the case when it got to the court.
Great. So a few weeks ago, the court issued its decision in this case. All told, 118 pages, including a majority opinion, 3 concurrences, and 2 dissents. So as you noted, the court in Skrmetti decided to focus only on the equal protection question. So let's start by unpacking the central equal protection at issue in the case, the level of scrutiny to apply to Tennessee's law. Can you explain how the justices answered that question?
Sure. So here's what the court in Skrmetti said. It rejected all of those equal protection claims I just articulated. And it said this statute actually discriminates on 2 grounds and only 2 grounds. It discriminates on the basis of age. So it bars minors from receiving these treatments, but not people over the age of 18. And it discriminates on the basis of medical procedure. So it allows the drugs for a whole range, almost all of the medical conditions for which they're indicated, but not one. So the court says it discriminates on the basis of which procedure you can get these drugs for, but neither of these trigger any heightened scrutiny or constitutional concern, the court says. So the court says there are ways in which you can get heightened scrutiny under the Constitution, but none of them are satisfied here. There's no sex discrimination, the court says. That would trigger heightened scrutiny, and the court would take a closer look at the law, but the court says that doesn't exist here. How does it reach that conclusion? Talked about how your access to the drug is going to depend on whether you're a girl or a boy in the state's view. The court says, no, that's the wrong way of thinking about it. It doesn't actually do that. There's no sex line being drawn in the law. All boys and girls can get the drugs for precocious puberty, for hirsutism, for gynecomastia, for all the conditions that the law allows. All boys and girls can get those drugs. No boys or girls can get the drugs for treating gender dysphoria. The law exempts gender dysphoria from the list of conditions for which you can get these drugs. So boys and girls are being treated the same, the court says. There's no sex discrimination. And likewise, the same formalistic reasoning. The court says cisgender kids and transgender kids can get the drugs for all those conditions for which it's allowed, and no one can get them for treating gender dysphoria. So we're not treating cisgender kids or transgender kids differently. We're just saying there's one medical condition for which you cannot get these drugs. And finally, the court says there's no evidence of animus. Tennessee is trying to protect kids from unproven medications. That's reasonable care and concern. That's not animus. So the court holds that the lowest level of review applies in this case because there's nothing constitutionally to trigger the court to take a closer look.
Great. So, in reaching the conclusion that Tennessee's law did not discriminate on the basis of sex or transgender status, the court cited Geduldig, a case from 1973 that dealt with pregnancy. Can you explain a little bit more about how the court used Geduldig and Skrmetti and why the court's use of this case is noteworthy?
Sure. Let me tell you a little bit about Geduldig in case you haven't read that case. Um, In the 1940s, California started a disability insurance program. Workers paid into the program every month, and if they became temporarily disabled, this money would cover this insurance program would cover them until they could return back to work. The program covered all disabilities except for pregnancy. So you couldn't get covered if the reason you were disabled was pregnancy. And the state in the 1940s is reasoning that when in its view, when women become pregnant, they're going to stop working. They're going to go home. So they shouldn't get money because they're not going to return to the workplace. This is for workers who are going to come back to work after their disability. The pregnant workers are going to stay home. So you can't get money for disabilities related to pregnancy. In the early 1970s, when women in California sued, and they said this discriminates on the basis of sex. We're not covered for this most common cause of disability. And the Supreme Court in 1974 rejected that claim. It held that this statute did not discriminate on the basis of sex. It only exempted one medical condition from coverage and discriminated on the basis of that medical condition and against the people who had that medical condition, but not discriminated on the basis of sex in general. So the court said in a sort of famous discussion in that case, we think, yeah, all the people who are pregnant are women. That's true. But on the other side of the line, there are men and women. Some women are not pregnant. And all those men and women on the other side of the line, they're getting covered for all those other disabilities. So if you look at it like that, you can see that the line it's drawing through humanity is a pregnancy-based line. Pregnant people are treated badly. Non-pregnant people are treated well. That's not a sex. That line doesn't accord with the sex difference. That is a medical condition that's triggering the discrimination, and that's okay. So that decision, Geduldig, rears its head in Skrmetti. Justice Sotomayor says in her dissent that that decision is egregiously wrong. I think that's very clear that it was an egregiously bad decision. I think it's also become antiquated over time. Congress immediately rejected it and said that, of course, pregnancy discrimination is sex discrimination. And for 50 years afterward, the court didn't cite that opinion in a majority opinion in a constitutional case. But now the court's reviving Geduldig, and it's extending it into the transgender context, which it has never done before. And it's saying, on the logic of Geduldig, the plaintiffs here lose because it's just one medical condition. Transgender people aren't targeted the same way women aren't targeted by pregnancy discrimination. Uh, I'll say two things about that. One, I think that is concerning, the revival of Geduldig, in part because I don't think that that logic is cabined to kids. One thing the court tries to stress in Skrmetti, that this case is just about kids. We might have concern for these drugs being used on kids, but then they cite this Geduldig logic that it's not discrimination against transgender people when you exempt treatment for gender dysphoria from coverage. That's a concerning piece of logic for, I think, the entire LGBT movement. And finally, I'll just say, as some of you might know, this is an anti-abortion tool. Skrmetti is not the first decision recently to revive Geduldig. That would be Dobbs, the 2022 decision in which the court overturned Roe v. Wade. The court went out of its way, even though that case didn't involve a sex discrimination claim, to say in dicta that, hey, by the way, if you want to challenge an abortion restriction on the grounds that it discriminates on the basis of sex, Justice Alito says, don't even try it because geduldig is good law. Remember that old case from the early 70s? That's how we still think about it. Any abortion restrictions do not discriminate on the basis of sex, and you can't think about equality when you're uh, bringing those claims. That's a dicta suggestion in Dobbs, but now it's really coming to the fore in Skrmetti. I think we'll see more of it, and I think it's a concerning development.
Yeah, for sure. So now I'd like to talk about the role of research in this case. We saw all kinds of empirical evidence marshaled in the amicus briefs, and all of the opinions relied on empirical evidence to some extent, even when they seem to say they don't need to. So can you tell us a little bit about how research informed and shaped this decision?
Oh, I could talk about this for an hour. I guess I'll start by saying, once the court held that this law gets the lowest standard of review, it's basically saying it's presumptively constitutional. The state doesn't need compelling reasons to pass this law. We don't really need to get into the fight over the research. The state can pretty much win its case. Nonetheless, the court gets into it a bit. Um, so here's the situation on the research. The American Academy of Pediatrics, the American Medical Association, the American Psychiatric Association, the American Psychological Association, the American Academy of Child Adolescent Psychiatry, and all of the leading medical organizations in the United States are in consensus that puberty blockers and hormones are sometimes indicated and are the standard of care for treating transgender children and gender dysphoria. The court in Skrmetti pretty much disregards this consensus. It is asking, does Tennessee have a reason for passing this law? And it looks to a study published overseas that wasn't in the record in this case, by the way, that wasn't relied on by Tennessee legislatures, that came out after this case had already been argued in the lower courts. And this study is called the Cass Review. And it was done in the UK. And the court cites it fairly extensively. I can't get into an entire analysis of the Cass Review in this space. I only have a couple minutes. So I'll say a couple of things. One, you shouldn't take my word or anyone's word. When it comes to research and data, you should look at it yourself. You can look at an excellent white paper on the Yale Law School website by Professor Ann Alstott and a group of international experts on medical care for transgender minors. After I read that paper, I looked at similar work in Ireland, Canada, and Australia. There is a lot of work out there at this point, and I assume there'll be more, uh, arguing that the Cass Review was very poorly done and riddled with error and deeply biased. So I'll just say, for example, the Cass Review is very concerned that there aren't in the literature on using these drugs to treat transgender minors, lots of randomized control studies. That means where you have two populations, you give one of them the drug, you give one of them the placebo, you look at how it turns out for them. As all of these critics point out, that is not generally what we have in pediatric medicine. That randomized control trials, there are ethics issues with doing those kinds of studies on people who can't consent and who are not going to get drugs that doctors believe may be helpful. So it is not the case that for many, many, many forms of pediatric medicine that what we have is the highest quality randomized controlled trials. And it's unlikely that we're going to get a massive amount of them in this context. That's not what we would be looking for, and that's not what we demand in other areas like, should you put in a NICU? Should you put in a breathing tube? Or should you try to get the kid to breathe on its own? Should you give formula? Or should you give donated breasts? All these kinds of questions. We don't have those kind of studies, and they're not expected. I could go on at some length about the problems of that study. It's citation of non-experts, people who aren't doctors, and some openly biased discussion about the problems of transgender people in that report. So I think it's concerning that the court is citing that study. And it's not citing the study to say, we know these drugs are dangerous. It's citing the study to say, hey, look, there's controversy. Some doctors say all the leading medical organizations in the United States say it's safe and healthy to prescribe these drugs in certain circumstances. Um, but some doctors don't. So in that situation, we have to leave it to the legislature to make those determinations. And I'll just say that really reminds me a lot of cases in history. If you look back, that was very much the argument in Loving v. Virginia in the fights over interracial marriage. Virginia was saying, look, there are some experts that say interracial marriage is okay. There are other experts who say these are socially degenerate people. They will lead to the downfall of society. They will hurt their children. They will cause all kinds of social harms to themselves. And so you should leave it to the legislature because there are experts on both sides of interracial marriage. Many of you probably remember the fights over same-sex marriage. Same thing, court saying, look, some people say same-sex marriage is okay, but there are others who say it will hurt children, it will cause everyone to get divorced, it will promote child abuse, it will make people ill, people who are doing it are trying to all this stuff, and states were arguing back in the day. So courts should leave that to the legislatures. This has that feel to me. And I'll just say finally, I think it's a worrisome sign for other LGBT cases that the court is willing to engage in this kind of both sides have an argument, so we can't really say, what's going to happen in the military case. There's no evidence that having transgender people in the military decreases military readiness at all. But what if Pete Hegseth says that it does? How is the court going to, if this is how it's acting with respect to this science, how will it react to all of the other science? I don't know, but I'm not heartened by the treatment of evidence in this case.
Yeah, so along those lines, Cary, I want to wrap up our Skrmetti discussion by thinking about the implications of this case. What do you think the implications will be for transgender people and LGBTQ people more broadly?
Well, I'll say two things. First, I would say, as a lawyer, I think it's very important to note that this decision was considerably narrower than it could have been. Like, in the case, there were concurring opinions that swept a lot more broadly. Justice Barrett wrote a concurring opinion, and in which she argued, transgender people shouldn't be a protected class. They shouldn't get heightened scrutiny when laws discriminate against them because they haven't faced a history of discrimination. That's one of the criteria we look at when we're going to determine which groups get heightened protection under the Equal Protection Clause. Should transgender people have not faced the kind of history of discrimination that would concern us, and so they shouldn't get heightened scrutiny under the Equal Protection Clause. Justice Alito kind of broke with his conservative colleagues and he said, come on, guys, I think this does discriminate against transgender people. I mean, it's a little bit of a logic. Yeah, it's barring gender dysphoria treatment, but who gets that treatment? Transgender people. It's discrimination against transgender people. And then he says, and that's okay. It's okay to discriminate against transgender people. That doesn't raise constitutional problems. So the court in Skrmetti said, we're not reaching any of those questions. We don't think this discriminates on the basis of sex. We don't think this discriminates on the basis of transgender status. So we're not saying it's okay to discriminate on the basis of sex, that it's okay to discriminate on the basis of transgender status. We're saying in this particular situation, that didn't happen. So all the questions of whether all the other anti-trans legislation does those things and might be problematic, we're leaving that for another day. We're just saying here, we had a medical treatment discrimination, and that is okay. That leaves a lot of room for lawyers. That leaves a lot of room for LGBTQ rights lawyers to say, this is a pretty narrow decision cabined to those facts. It doesn't have a lot of implications for a military ban or a sports ban or a bathroom ban or cases where adults are being targeted. There is a lot of argument that one can still make after Skrmetti because of the way that it was written. Now, I am going to reverse course and not undermine, but counterpoint to what I just said, which I think is right. Uh, there have been some concerning signs just in the last couple of days about the implications of Skrmetti down the road. So after the Supreme Court releases all its decision for the term, that kind of it cleans up all its business at the end of the term. And in the course of cleaning up its business, uh, it vacated the decisions in 4 federal appeals courts in which transgender plaintiffs won. And it said to those courts, we're vacating your decisions on behalf of the transgender plaintiffs. You need to go back and reconsider those decisions in light of Skrmetti. 2 of those cases involved Medicaid exclusions for gender affirming care. One involved a birth certificate policy, and one involved public school teachers' health insurance plans. And the court is saying, you need to take another look at the victories that you handed to transgender people now in light of Skrmetti. Those cases did not just involve the facts in Skrmetti. They were more broad, and the court is saying Skrmetti would seem to apply, and that's concerning. I think there'll be some knock-on effects of Skrmetti. Here's a couple other things that happened. The court, at the same time, did not take up the 2 cases in which transgender plaintiffs lost, and that was the claim that parents' rights are violated in Tennessee and Kentucky by gender-affirming care bans. The court let stand decisions saying that it does not violate parents' rights. And finally, it granted cert. Next term, we're going to be hearing 2 transgender sports ban cases. The lower courts invalidated those bans as unconstitutional. The Supreme Court has granted review in those cases. So, do I think the trajectory here is good for LGBT rights? No.
Thanks, Cary. With that, let's turn to the other but lesser known LGBTQ rights case decided by the court this term, Mahmoud versus Taylor. Can you tell us what this case is about and how it got to the court?
Sure. So Mahmoud v. Taylor in 2022, the Montgomery County School Board in Maryland, it's a very large and diverse county, it decided to introduce several LGBTQ inclusive books for use in its elementary school classrooms. It said, we're a very diverse community. We want the books to reflect all the different people in the community. Part of our community is LGBT. We want to have books representing those families. So books like Pride Puppy, Uncle Bobby's Wedding, and a couple of others were introduced into the classroom. These books could be in the classroom. They could be used for quiet reading time, reading circles. The teacher could read them to the class. Initially, the school board allowed parents to object to the use of those books and pull their kids out of class if those books were going to be used. But the school district rescinded that option when it found that it was completely unworkable because the books were in the classroom and they couldn't predict when they were going to be seen or used. And so it was administratively impossible to pull the kid to give the parents notice and allow them to pull the kids out, given the way the books were being used. And the school said the school board said we're also worried that it's stigmatizing to the kids with LGBT families. Every time a book with a family that looks like yours comes up, kids are going to leave the classroom because they don't want to see that offensive content. We don't want that for our classrooms. So, a set of parents, Catholic, Ukrainian, Orthodox, and Muslim parents, sued the school district, saying their First Amendment free exercise right, their right to exercise their religion, is being violated. They lost by the use of these books and the inability to opt out from these books. They lost below, and the Supreme Court took up their case.
Yeah, so at the Supreme Court, the majority, the 6 conservative justices on the court, held that the school board's policy burdened parents' rights to free exercise, and as such, subjected the policy to strict scrutiny. So can you unpack the court's holding and the dissent's response?
The court, in this case, sided with the parents, and it said the following. All right, I'll back up and start by saying for that this was a bold claim by the parents. This was designed to sort of push at the law. For decades, free exercise claims have been governed by a case called Employment Division v. Smith. And what Employment Division v. Smith says if you have a neutral, generally applicable law that incidentally burdens your religion, that doesn't trigger heightened scrutiny. That's a presumptively constitutional law. What triggers heightened scrutiny is if the law targets your religion. If the law is singling you out or motivated by anti-religious intent, that's going to trigger heightened scrutiny, but not these generally applicable neutral laws. So the school board here uh, argue that this is a neutral, generally applicable law. It's maybe incidentally burdening people's religion, but it's not targeting anyone on the basis of religion, so it shouldn't be a problem constitutionally. And the court rejected that. The court said, in this context, the general free exercise rule does not apply. It said that heightened scrutiny will apply when the government requires parents to submit their children to instruction that poses, quote, a very real threat of undermining the religious beliefs and practices that parents wish to instill. So even if the rules are generally applicable and neutral, they are going to trigger heightened scrutiny if they threaten to undermine the religious message that the parents want to convey. This is interesting because several decades ago in Smith, it was Justice Scalia who rejected that way of thinking. He said it would lead to anarchy. He said people can claim religious and challenge and claim exemptions from every single rule out there, asserting that the policy interferes with their religion. And the worry is that that's going to make the religious rule paramount over the rule of law. But the court in Mahmoud says that's not a concern because the courts will only excuse people from rules and policies where the threat that a governmental policy will undermine the religion is very real. So how's it going to determine when the threat is really seriously likely to undermine religious teaching? So the court says basically it's very fact intensive. We're going to have to decide in any case. We're going to look at the specific religious beliefs, the practices asserted, the specific nature of the educational requirement, the curricular features at issue, the specific context in which the instruction or materials are presented. Are they presented in a neutral manner? Are they presented in a manner that's hostile to religion, etc.? It's a very flexible test, and it leaves courts a lot of power to determine when the material threatens to undermine religion and when it doesn't. The other thing that the court says is actually this doesn't change very much. We decided in 1972, we decided a case called Yoder, and that is when Amish people in Wisconsin wanted to pull their children out of schooling at 8th grade, whereas when Wisconsin required that you get schooling until the age of 16. And the court sided with the parents there. So the court says this is quite like that. And it also cites another 1943 case called Barnett, where Jehovah's Witness parents were allowed to not have their children salute the flag. And so the court says we've always granted First Amendment free exercise exceptions in cases like this. The dissent says, no, we haven't. This is a wild departure from precedent. This is a enormous, untenable expansion of free exercise. The dissent says Yoder and Barnett were very different cases. Yoder and Barnett were about affirmatively compelling parents to directly violate their religious beliefs and practices. Those laws didn't incidentally burden the parents' religion. It required the students to directly violate the religious teaching and not engage in the religious practices. And the dissent says that's not at all similar to what is going on here. Here, kids are being exposed to books that represent everyone in the community. No one's being asked to give up their religion. No one's being compelled to violate key tenets of their faith. These are just books with gay people in the classroom. So Justice Sotomayor says this is actually the opposite. This case is requiring the government itself to behave in ways that further the individual's spiritual development or development as his or her family. Grants the religious people control and veto power over the public schools, is what the dissent in this case says. And finally, the dissent says, we all know what's going to happen, and maybe the purpose of this challenge, which is this is going to chill the use of any of these books in schools. Because as we know, schools can't administratively handle the burden of this and that, every kid popping out of the classroom at different times for offensive content. So what are the schools going to do? They're just going to remove the books from the classroom. And that is why the court thinks it's importantly wrong.
Yeah, so you mentioned the court's heavy reliance on Yoder here, and it seems like there were a few other directions, maybe less far-reaching directions, that the court could have gone in this case. It could have found that the school board's policy was infected by animus based on the statements made by some of the board members. That would have been going kind of the masterpiece route. Or the court could have found that the policy was not neutral or generally applicable because the board allowed opt-outs from other lessons, like the court said in Fulton. So what is your sense of why the court didn't go in these other directions?
Yeah, it's an interesting question. There were a lot of more minimal routes the court could have taken, and it took instead a maximalist route in this case. I guess I will say that this case was teed up by an important conservative uh, religious liberty organization, the Becket Fund. There's a multi-year campaign to expand free exercise on behalf of religious groups. Um, I think the court took this case because it wanted to say something. It was not looking just to decide the case on the most minimal grounds that it could possibly do. I think it was wanted to say something, wanted to say what it did. And I think there's evidence in if you just look at the record in the case, that the court really wants to frame this in a certain way to enable it to reach the holding that it does. And I guess I would just say a little something about the books in this case. So at oral argument, the court talks about this book, Pride Puppy, uh, and Justice Gorsuch asks some questions. He says, this book, parents object to it because it is promoting to the very youngest kids bondage and sex work. And I have seen interviews with the author of this book. It's a very flummoxing statement because if you look, you don't see a lot of depictions of bondage or sex work. As this puppy gets lost at a pride parade and the community helps the child who's lost the puppy find the puppy. That's the story of the book. And the thought is that this lady right here is wearing a leather jacket. And that may be just the source. I will point out the dog also has a leash. That may be the source of Justice Gorsuch's assertion that this board book is about, and I'm not being hyperbolic. He says this book is about bondage and sex work. And that may be the genesis of that. And we have a similar in the opinion itself. Justice Alito spends some time talking about Uncle Bobby's wedding. And it's interesting what he says about Uncle Bobby's wedding. So Uncle Bobby's wedding has a very familiar plot to any of you who have read children's stories, which is Uncle Bobby is getting married and Chloe, his niece, is anxious because Uncle Bobby's her favorite uncle and they spend a lot of time together. And she's worried now that he's getting married that she's not going to be able to spend as much time with him, that his husband will take up all his time and she'll be forgotten, right? There's a million books about remarriage or a new baby or where this is the plot of the book. And the books, it turns out, actually Uncle Bobby and his husband now love Chloe and take her to all the places, and so the problem is resolved, and it's a sweet story. But um, when Uncle Bobby announces that he's going to get married, the book says the family's all happy except Chloe. And then Chloe's mom talks to her and says, "No, this will increase the love. It will increase the number of people who spend time with you, and there's a happy resolution." But Justice Alito says what this book is saying is that Chloe has objections to the same-sex marriage, and she is forced by her parents to accept it. And she is reprimanded and told, you may not have anti-LGBT thoughts, that's not allowed, and you must come around and submit. So Justice Alito reads the book in that way. Um, the book explicitly says that her problem is that she's worried about the time that she spends with her uncle will decrease. And this book isn't about bondage. So when I see this literary interpretation in this case, I see a court that is trying very hard to construct a narrative where we have an assault on religious people in order to hold that they need the defense of the First Amendment. And it reminds me very much, the last thing I'll say is just reminds me of the praying football case from a couple of years ago, Kennedy versus Bremerton. That was a case in which a high school football coach was praying Christian prayers on the 50-yard line during school football games, dozens and dozens of kids coming around him. And the court found that he was not engaging in school prayer. He was engaging in a quiet moment of private reflection. And some kids might have been joining that voluntarily, but no one was being coerced. No establishment of religion was going on. And Justice Sotomayor, in her dissent, publishes a picture of the massive prayer event going on with 50 kids and the coach, and says, you're manipulating the narrative. And I think that has gone on here in the interpretation of these books, all of which to say, I think the court is actively pursuing a certain narrative, a certain constitutional agenda. It doesn't seem particularly bound by the facts. Seems intent on expanding traditional religion's dominance in public life.
Yeah, thanks. That was an incredibly powerful explanation of kind of what they're saying is going on there and what's actually going on. Thanks for that, Cary. And so you touched on this a bit already, but just to flesh it out a little more, what are the implications of this case, both kind of practically, how will schools respond, how will parents respond, and legally, how will this decision impact future cases, particularly cases at the intersection of LGBTQ rights and First Amendment rights?
Well, the dissent says that essentially this decision gives religious parents a veto over materials in the classroom, and says we should be worried that schools will just pull these books or not put them in the classrooms in the first place. And I really think that that is inevitably going to happen. My mother was an elementary school librarian. I have been watching these culture war fights for decades. If you're going to have parents objecting, and now they have a constitutional right to receive notice and to pull out their children anytime they object to content in a book, most school administrators are just not going to have these books in the classroom. That's how they're going to deal with the problem. And everyone knows that. Everyone's very well aware of that. I thought it was telling, one of the main commentators I have seen writing about this case in the press has an article that says, Mahmoud v. Taylor, this is not a culture war. And I think the person is saying that because it very clearly needs to defend, because very clearly it is a culture war. This is all about a school board that tried to say we want books inclusive of LGBT people in the classroom, and some parents saying we don't want to acknowledge that part of our community as a healthy, functioning part of our community. And it's a culture war. And I think it will result in books being pulled from classrooms. I think it will result in lonelier kids who don't see their families reflected. I think there will be stigmatization, and that absolutely will occur. more broadly, beyond this context, Justice Kagan wrote a couple years ago about the weaponization of the First Amendment. I think this is part of a general weaponization of the First Amendment. Here, free exercise, historically used to protect minority groups, subordinated groups who want an exemption from the general laws because it doesn't allow them to practice their religion. Increasingly, we're seeing the First Amendment as a sword rather than a shield, as a sword to come out and block anti-discrimination law and block the rights of LGBT people in particular. Dismaying to me, because we've been through this movie before in the civil rights era. Restaurant owners, for instance, who didn't want to integrate their restaurants, claimed First Amendment right, claimed religious right. My religion dictates segregation, so you can't make me segregate my restaurant integrate my restaurant. And the court said, yes, we can. The First Amendment doesn't give you a right to violate anti-discrimination laws and to treat other people badly. It was designed to protect you from coercion and force by the government. And I think we're seeing a backsliding from that uh, principle. And I think we're seeing the weaponization of the First Amendment in the LGBT context. I could cite a lot of cases. I'll just cite two. We now have two recent federal appeals courts decisions, one of them saying that a teacher has a First Amendment constitutional right to misgender students. So if you have transgender students, the teacher has a constitutional right to call them by the wrong pronoun. Similarly, we have a federal appeals court decision saying that a teacher who is transgender does not have a First Amendment right to introduce herself as Ms., to use her appropriate pronouns, that's part of the curriculum and teaching duties when she introduces her name, and she has no protected First Amendment right to use her correct pronoun. I could talk a lot about the inconsistencies in First Amendment law at this point with respect to who is getting rights and who is not. I'll just say I think Mahmoud is a pattern, as part of this pattern. We'll see more of it, that speech and religion rights are now being wielded as weapons against LGBT rights.
Yeah, so one final question before we go to the audience Q&A. This has been so great, Cary, so thank you so much for all this information. But just wrapping up, I want to ask you, as a law professor, what concerns you most about these decisions?
A couple things. One, I'll say just the rule of law. Um, We're increasingly getting tests, and actually this Mahmoud test is a good example of it. The court says it's very fact intensive. We're going to decide, is it threatening people's religion? How's it being used? Is it really threatening? Is it anti-religious? Is it not? Is it coercive? Is it's not? There's almost no guidance in this test. And the worry is that that leads to favoritism and inconsistency. And I could cite just in these two cases how parental rights are being treated in terms of thinking about the rule of law and consistency. So in the Mahmoud case, we have extreme concern for parental rights, right? Parents need to be able to pull their kids out and, in fact, dictate the books in the curriculum because it might infringe on their religious practice if their children are exposed to these books, and parents really need to have say and control over the upbringing of their children. Okay, that's a principle. But then we get to Skrmetti, and the state is saying to parents and doctors and kids, your parents might think that this treatment is right for you. Your parents and your doctor may think that this is what's going to keep you safe and healthy, but you don't get to say. The state will determine what is the appropriate medical treatment for your child. Parents do not have the right to make that determination. That does not seem to me a consistent application of the apparently deep concern for parental rights that you see in a case like Mahmoud. So I am troubled by, from a rule of law standpoint, I am troubled by the inconsistencies in a lot of the cases that I've talked about today, where the only consistency seems to be that the LGBT plaintiffs lose, honestly. And that's not a legal principle. And then I guess the final thing that I would say is I'm worried by this narrative, and you see it in the Mahmoud case in particular. I'm worried by this narrative that LGBT people are really the aggressors, that LGBT people are have an agenda and are trying to take over and trying to control things. And we need the law to step in to protect non-LGBT people, children, and families from this powerful agenda. Um, when the reality of the situation is a tsunami of anti-transgender lawmaking and activism. When Trump was running for president, he spent over $200 million on anti-transgender ads, made it a centerpiece of his campaign to regulate against transgender people. We're seeing a massive upswell. Every year is a record-breaking year over the last few years in anti-transgender litigation and legislation. There is real suffering and cruelty being faced by this stigmatized minority. And there is an attempt by anti-transgender forces, anti-LGBTQ forces to say, to flip the narrative on its head and to say, actually, this community is the dominant aggressive one. And I worry because I think if you read Mahmoud, you would have cause to be concerned that the court seems to be agreeing with that narrative and telling that story about our history and politics in the current moment. And I think that is backward. I think that is harmful. I think that will not lead to equality and liberty under the 14th Amendment.
Yeah, thanks, Cary. Very sobering. Thank you so much for this discussion. We have so many great audience questions and time for a few of them. So I want to start with a question about Bostock. So how does Skrmetti intersect with the court's decision in Bostock? And for those unfamiliar with this case, this was a case in which the court held that discrimination based on transgender status constitutes discrimination based on sex under Title VII.
Yeah, so Skrmetti did not say anything about Bostock. Skrmetti said, actually, we don't have discrimination on the basis of sex, and we don't have discrimination on the basis of transgender status. So we're not even going to reach any of those questions, and we'll leave them for another day. It's there is that day will come. So in Bostock, the court said under Title VII of the 1964 Civil Rights Act, which prohibits discrimination on the basis of sex in employment, that prohibition against discrimination also covers discrimination on the basis of sexual identity, sexual orientation and gender identity. And so gay people and trans people got covered under federal employment discrimination law as a result of the Bostock decision. One of the big questions on the horizon is, will they also be covered under the prohibition against sex discrimination under the 14th Amendment of the Constitution? And Skrmetti does not address that question. That we will face that question another day.
Great, thank you. So a few questions here about the various concurrences in Skrmetti. So how concerned should we be about Thomas's concurrence in which he basically says that, expresses skepticism about research and data, in particular kind of social science data?
Yeah, Justice Thomas writes quite a striking concurrence in Skrmetti. Which is, I think it's fair to call it something of a diatribe against experts. So he says, the majority has the more tepid kind of, there are experts on both sides, so we don't know, it's not our place, we'll just let the state decide that. Justice Thomas says, ugh, experts, medical experts. Experts are always telling us the way things are, and we don't need to listen to that. Experts have often been wrong. 100 years ago, experts believe in eugenics. So that just shows you like medical experts and data and how that's all manipulated, and it's elite thinking that is often deeply prejudicial and problematic. And he's basically saying, as I mentioned, every leading medical organization in the United States believes that this care is safe and indicated for transgender youth in certain circumstances. And he says, that's irrelevant to me. And it's irrelevant to the law. The state should get to make determinations about these things, and it doesn't have to follow the experts. And he cites I thought it was interesting because he cites the example of fetal pain. And he sort of says, the experts may say that early stage fetuses, biologically, it's impossible for them to feel pain. But people may feel that they do. So the people should have the right to legislate uh, abortion in various ways because they feel that it might be possible. This is, I think it's a pretty extreme view. And it's not surprising to me. He does not like experts. He has expressed his view repeatedly. Um, I don't think the court will go that far. Uh, but I could go on about uh, the general attack on expertise. If you look at what's happening in the administration right now, for instance, there is a massive attack on expertise. It has to do with vaccine. Look at HHS, like vaccines, medical authority and knowledge in general. I think that's probably part of that movement, and we will see where it leads.
Yeah, thanks for that. And then turning to Justice Barrett's concurrence, specifically uh, that she rejects that there's been kind of a history of de jure discrimination against transgender people. How concerning is that, and what do you make of that?
Gosh, it's concerning. Um, it's concerning It's concerning because it is very, very wrong and misinformed. Um, and it's concerning because the Solicitor General did not have a great answer to it at oral argument. The Solicitor General, Elizabeth Prelager, was one of the best lawyers I have ever seen in my entire life. She is absolutely incredible, brilliant lawyer. I'm in awe of her abilities. But when she was asked at oral argument, she kind of didn't have about whether there was discrimination against transgender people historically. She kind of said, I'm not sure. I don't know that there has been. We have a lot of work to do because um, I have shelves and shelves and shelves of books about the discrimination against LGBT people and transgender people in particular, historically, including in law, by the way. Um, and the court, I think the court may not know about that history. It would worry me enormously if the court just starts making decisions based on the assumption that transgender people have not faced discrimination. Justice Sotomayor does a good job in her dissent of saying, although it's quite brief, she's like, there has been enormous amounts of transgender discrimination. There have been laws barring cross-dressing. There have been laws of police allowed to arrest transgender people stretching back a very long time in housing, in education, in all sorts of areas, including de jure discrimination. And Justice Sotomayor says, you only need to look around you now to see, even in 2025, the level of discrimination that transgender people are facing. So I think that is a call to arms. Historians, researchers, the court is saying it's unaware that there's any history against transgender people. Let's make sure that history is brought before them because we don't want a slew of decisions that assumes everything has been fine and dandy for transgender people in the United States throughout our history.
Yep. So thank you, Cary. Time for one more quick question. So can you talk kind of about how Mahmoud might impact the Smith case? Is Smith still good law? Has it chipped away at that decision? What do we know about Smith now going forward?
Yeah, that's a really good question. I'm not sure the court entirely answers that question. So Smith is the case that said a neutral, generally applicable law is constitutional if it incidentally burdens religion. The problem is laws that target religion, and those are the ones that get heightened scrutiny. This case says, all this case says is in this, and it kind of says in this situation. and I don't know what it means by this situation and how broad is that gonna sweep. In this situation, Smith doesn't apply. In this situation, we have a even if you have a neutral, generally applicable law, we're granting heightened scrutiny if we think there's a very real threat of interference of parents transmitting their religion to their kids. Um, but the court doesn't overrule Smith formally. Um, how broadly will this exception to Smith run? I don't know. As the questioner may know, we've had several decisions that have kind of chipped away at Smith. So Smith is really foundering. The court hasn't given it the axe. It's still law as far as we know, but I think there are growing exceptions to it. This is certainly a big one. Time will tell.
Thank you so much for this, Cary. And we're right at time. That was incredibly insightful and helpful and informative, a little bit scary, but thank you so much for your sharing your expertise with us today. And thank you everyone who joined us.